Section 11, that Section 11 stand part of the bill. Is that agreed? Section 12, that Section 12 stand part of the bill. Is that agreed? Section 13.
Not agreed. Section 11 not agreed. I did say not agreed, Carol.
You got to speak up. We've gone to 12.
Yeah, well, I'm sorry, I did say 11 not agreed. I'm sorry.
No, I'm gone on to 12, but please do speak up. I didn't hear you. My apologies. Section 13, Amendment 10, in the name of Senator McDougall, Boyhan, Clonan, Conway, Keoghan, McCarthy. Has the amendment been moved?
13, is it?
So Section 13, Amendment 10.
10.
Section 11 is not agreed.
Not agreed.
I know,
it isn't
but
agreed.
you've
Well,
got...
if you want votes all afternoon,
I'm not...
Senator Crockwell said it was not agreed. Maybe he didn't. He wasn't heard.
He wasn't. I've got to be able to hear.
Well, I have to say to your chair, it is a section of huge importance, and just rattling off in the way you have is most unfair, especially if a senator says it's not agreed, and he's then just bulldozed out of the way.
I'm not
bulldozing. So I'm saying to Cathaoirleach, if you want votes all afternoon on every comma in this bill, you'll get it now. But if Section 11, if the House wants to go back to Section 11, it is entitled to do so, as you well know.
All right. Senator, as the Minister has no objection, but I would ask members, if you please, you have plenty of voice, and we do, just to be clear, we do rattle through sections, because when we're getting to...
Efficiency.
Yeah, no, thank you. I'm glad no one's against efficiency, but if you have a section you want to talk on, please speak up, okay? As the Minister is agreeable and the House is agreeable...
No. Senator Crockwell and myself spent an hour talking about this section this morning and came here with the express intention of opposing it.
All right. Section 11.
Yes, Carl, look, thank you, and I'm sorry that I didn't speak up loud enough for you, but as you know, I don't hear you all the time.
Most unusual.
Yeah, I don't hear you all the time either, so I was trying to adjust my hearing to see what was going on. Section 11, Minister, Section 11 amends the Section 26 of the Principal Act. And in looking at the amendment, it strikes me that all of the safeguards that were included in the 2009 Act, which was introduced indeed by a colleague, Senator McDougall, all of those safeguards are gone. And it strikes me that this is a highly favourable amendment to media. And anybody who wants to take the good name of a person can simply, based on an allegation between two people, a media observer hears it and can then go and write a story, and it is perfectly cleared, providing they can reach what is called the public interest. Where does the public interest start and stop? If we look even in today's newspaper, there's an article based on innuendo, based on Dúirt van Lum go Dúirt van Leahy, no names mentioned, no pack drill, right? And we're seeing this all the time, and it is totally unacceptable. But we're told in the article in today's paper that they couldn't print the name because of defamation laws. But as in all of these things, they probably laid enough breadcrumbs to lead the article to 2 or 3 people in this House or in the lower house. And it's simply unacceptable that you're taking away the safeguards that are included in Section 26 of the 2009 Act. Let me just have a look at some of them that are there, if I may. Thank you. In the 2009 Act, for the purposes of the Act, you must be able to show that the statement is in respect of which action was brought was published in good faith. right? Publishing stories in good faith is something I don't see a lot of lately. Certainly the article that's published today doesn't strike me that it's in good faith in the first instance. In the course of, or for the purpose of the discussion or the subject of public interest, the discussion of which was for the public benefit. Again, it's typically members with high-profile names, whether they're members of the Oireachtas or whether they're entities outside the Oireachtas. Stories like that published, we need an extremely high bar. You cannot have a situation where people's names can be used based on some accusation that's made by person A about person B, which allows a media entity to then publish a story naming person A and being exempt from defamation laws purely because they are only reporting in the public interest what was heard. I'm deeply, deeply concerned by what I see here. I'm looking at the part 2 of section 26. Down at the end of that, the failure or refusal of a plaintiff to respond to attempts by or on behalf of the defendant to elicit the plaintiff's version. Right, somebody contacts you and says they want an answer to something, and you refuse to provide it. You're protected in the 2009 Act. The individual is protected. The court or the plaintiff version of events shall not constitute or employ consent to the publication of the statement or entitle the court to draw any inference from it. The last part of it in this section, the court means in relation to a defamation action brought in the High Court. The jury of the High Court is sitting with the jury. Defamation action does not include an application for a declaration order. The point I'm trying to make here is that we can't have a situation where we ease up. We should. You mentioned a little while ago you're all for free speech. I'm all for free speech too. But if we look, I heard somebody earlier on advert to social media. Free speech in social media, and we have no recourse whatsoever. They can say anything they want. In a recent statement on social media, somebody said that I was a person who supported child abuse, right? And I have no reaction and no action against that person because I don't know who they are, and I have no action against the organisation that allow it to be published on their website. And yet, it is widely read. So I'm saying we need to raise the bar, not to make it easier under any circumstances. We need to make it extremely difficult to write an article that will identify an individual. And going down your direction with this bill, it'll be much, much easier to name the individual. If you were writing the article in The Independent today, you would actually say the name of the individual, because you'd be covered under your Act to do that. I'll leave it at that for a moment.
Senator McDougall.
Curdig, I strongly urge on the Minister that he reconsiders this particular amendment. This amendment to the Act of 2009 was tendered in the course of the Dáil debate by the Minister. It's not referred to, as far as I can see, in the original explanatory memorandum. And it actually promises a very, very radical effect of change in the defamation law of this country. Now, I just think that the House should be aware that back in 2006, 2007, when the 2009 legislation was being prepared and was actually commenced in this House, I remember sitting where the Minister is now, and somewhere behind where Senator Conway is, I remember an impassioned speech against Section 26 of the original bill being made by none other than Senator David Norris. he claimed that I was opening the floodgates to the defamation of public figures, and that he was passionate in his condemnation of the reform that I proposed at that time. Now, it's important to put on the record of this House what the existing law is. It is as follows. It shall be a defence to be known, and in this section referred to as the defence of fair and reasonable publication. Mark the words, fair and reasonable. To a defamation action for the defendant to prove that A, the statement in respect of which the action was brought was published, 1, in good faith, and 2, in the course of, or for the purpose of, the discussion of a subject of public interest, the discussion of which was for the public benefit. So it's not just enough that it's public interest, it's public benefit as well. And secondly, that it was done in good faith. Those are the ingredients of the law at the moment. B, that in all of the circumstances of the case, the manner and extent of publication of the statement did not exceed that which was reasonably sufficient. So there is a threshold in the existing law. This is the law of the land as we stand here in this House now, which says that the defence of fair and reasonable publication was contingent on the establishment by the defendant that the manner in which the matter was reported, or the statement that was made, did not exceed that which was reasonably sufficient. And C, in all of the circumstances of the case, it was fair and reasonable to publish the statement. So the journalist or the newspaper has to say it was fair and reasonable to publish this statement. That's the law as we have it at the moment. And if you fail, I mean, recently we had the case to which the minister tangentially mentioned, was it fair to criticise Gerry Adams in the way the BBC did? And the jury said it wasn't. Right? But that's being abolished now. The fairness test is being taken out of defamation law. And then subsection 2 says that for the purpose of this section, the court shall, in determining whether it was fair and reasonable to publish the statement concerned, take into account such matters as the court considers relevant, including any or all of the following. A, the extent to which the statement concerned refers to the performance by the person of his or her public functions. So that's an issue. Does this statement concern the performance by a person of his or her public functions? B, the seriousness of any allegation made in the statement. And we're getting rid of, we won't bring in seriousness at all into our law, except for companies. C, the context and content, including the language used of the statement. D, the extent to which the statement drew a distinction between suspicions, allegations, and fact. Just let's contemplate that. The court is required, as at present, whether it's a jury or a non-jury trial, it's required to say, did this statement draw a distinction between suspicions, allegations, and facts? E, the extent to which there were exceptional circumstances that necessitated the publication of the statement on the date of publication. In other words, was there urgency that this story be published on the day? F, in the case of a statement published by a periodical by a person who at the time of the publication was a member of the Press Council, the extent to which the person adhered to the Code of Standards of the Press Council and abided by determinations of the Press Ombudsman and determinations of the Press Council. This was to try and had the effect of saying, you know, if you're a newspaper that is part of the Press Council, Do you actually follow its standards at all? Do you comply with its recommendations? If the Ombudsman of the Press Council corrects you or demands that you publish a retraction, do you do it? And G, in the case of a statement published by a periodical by a person who was at the time of the publication not a member of the Press Council, the extent to which the publisher of the periodical adhered to standards equivalent to standards specified in the previous section. In other words, if you had an English newspaper or an English magazine, did it follow the kind of standards that the Irish Press Council put in place? And those standards are really important. You know, check out your facts. Put the story to the person about whom you are writing. Those are all part of our law as we stand here today. H, the extent to which the plaintiff's version of events, that's the person about whom the story is written, was represented in the publication concerned and was given the same or similar prominence as was given to the statement concerned. And you just have to go back to the Adams case recently, and you'll see that his denials were published, but the allegations were given far greater prominence. If the plaintiff's version of events was not so represented, the extent to which a reasonable attempt was made by the publisher to obtain and publish a response from that person, and J, the attempts made and the means used by the defendant to verify the assertions and allegations concerning the plaintiff in the statement. In other words, a duty of verification. That's in the law as we presently stand. And none of this will be the law if we pass this bill in the form that the Minister is proposing. None of this will be in the law. The fairness goes out, the consideration, well, did you make an attempt to verify this? All of that is swept aside. And then, as Senator Crockwell said, the failure or refusal of a plaintiff to respond to attempts by or on behalf of the defendant to elicit the plaintiff's version of events shall not A, constitute or imply consent to the publication of the statement, or B, entitle the court to draw any inference therefrom. So, as has happened on many occasions to many people in public life, we intend publishing tomorrow about you the following. We're giving you your chance to respond. If you then ring up your solicitor and he says, under no circumstances respond, because they'll publish a denial story, Senator Joe Soap denies allegations of corruption. That is not permissible as an argument in court as the law presently stands. So in other words, if you're told by your lawyer, this is false, but if you would start mud wrestling with the journalist in question and say, that is untrue, you end up facing a story. Senator Joe Soap has denied an allegation by X, Y, or Z that he did or did not do X, Y, or Z thing, or was not corrupt, or whatever it may be. That's the law as we have it. And, you know, it's not an accident that that's the law, because I'll tell the Minister that the generation of this particular Section 26 was done with the greatest of care and engaged, and without divulging at all cabinet confidentiality, it engaged the minds of ministers at great length at the time. Because they could see that if you do what the minister is now proposing, huge consequences would follow for people in public life in particular. Now, that is the law that we have established today. And some of it has been difficult to rely on by defendants in jury cases, because a jury would say at the end of the day, it wasn't fair. And that's the end of the matter. But what we're proposing now to put instead of it, and ask members of this House to look at it very carefully, it shall be a defence to be known as defence of publication on a matter of public interest. Well, what's different? The phrase fair and reasonable has been dropped. That's just the title of the defence. Fair and reasonable is dropped. To a defamation action for the defendant to prove in all the circumstances of the case 3 things. The statement in respect of which the action was brought was on a matter of public interest. The defendant reasonably believed that publishing this statement was in the public interest, and the statement was published in good faith. So, if somebody goes to a journalist and accuses a TD, a minister, a senator, or anybody else in public life for that matter, of very grave wrongdoing, from child abuse, as mentioned by Senator Crockwell, or public corruption of one kind or another. If those 3 things are established by the defendant, that the statement in respect of which the action was brought was on a matter of public interest, and it would be of huge public interest if one of us had acted corruptly, or was corrupt, or a member of the Dáil or a member of the government, of huge public interest by definition. So you're over that hurdle before you start. That the statement, second point is that the statement was in respect of which the action was brought was on a matter of public interest. Secondly, that the defendant reasonably believed that the statement was in the public interest. Well, if a minister's accused of corruption, is a journalist or a newspaper not very easily in a position to say, well, if this accusation has been made, it's in the public interest that it should be disclosed. For instance, if a well-placed member of An Garda Síochána goes to a newspaper or a newspaper journalist and says, Minister X is corrupt, or Minister Y is, although Minister for Children has a record like that which was alleged against Senator Crockwell. That's in the public interest. And publishing it is undoubtedly in the public interest because the public are entitled to know that a member of An Garda Síochána believes that that particular person is a danger to children. Right? And the third point is that the statement was published in good faith. What does that mean? That the journalist believed the guard who blackened the public figure. All 3 ingredients are then established as by proof. I believed it was true. It came from a credible source, and in view of the nature of the charge, it's in the public interest that the public knows about. Now, that is the test that this minister is putting before us in this House in future to establish a defence of publication in the public interest. Any newspaper which satisfies those 3 things, that they in good faith believe it, that they have a good source for it, that the nature of the charge is of very great public importance, and that it's important that the public should know that a senior Garda suspects a person of that offence. then they can publish. There's no requirement in the minister's provision that you even have to bounce the story off the person you're going to defame. None whatsoever. You don't even have to lift the phone to him, as long as you believe in good faith that the story you've been given by a member of An Garda Síochána is true, that it affects the person's, it's in the public interest that if it's true, that the public should know about it, and thirdly, that the matter is one which should be published in the public interest. Well, if I, as a journalist, received information that the Gardaí were investigating a minister in the present cabinet for corruption, if I was a journalist, first of all, I might ask the Garda, are you sure of what your accusation is? Yes. Is it in the public interest? By definition it is. And can I publish it in good faith? Of course I can, because I believe it's true. That is the test that this bill is proposing. Now, what is it? Just going back again to the existing law, which was carefully calibrated to put some balance. Before I go on to that, it means that tomorrow, if those three things are satisfied, any journalist can publish that story on the front page of any newspaper. And it is a good defence to establish those 3 points. Now, and if the minister or the TD or the senator or the bishop or whoever you want faces that headline, it's a defence, a good defence. It's the end of the matter. If the journalist and the editor say, we believed it to be true, it was obviously in the public interest, and publication of it was in the public interest. It was obviously in the public interest, and publication of it was in the public interest. We didn't even bother to ring up the individual in question. No, because the evidence we had, we saw the Garda file. So that's enough for us. We don't think that the Guards would have invented this. So there it is. It goes on the front page, uncontradicted. Now go back to what the law is at the moment. That the law at the moment is that it's a fair and reasonable publication. So it has to be fair. What is fairness in this context? The fact that the Guards suspect you of something should be drawn to the attention of the people at large. Is that fair? Is it fair? Is it consistent with, for instance, the presumption of innocence? That because Guards suspect a person in public life of doing something wrong, that can be published without more. Secondly, that in the course of, for the purpose of the discussion of public interest, the discussion was for the public benefit. It's important under present law that the journalist says it has to be dealt with now, because it's for the public benefit that it's dealt with now, not down the road when there's a jury trial going to happen in it. Now we are entitled to know about it, because that's what the Guards suspect. And in the circumstances of the case, the manner and extent of the publication of the statement didn't exceed that which was reasonably sufficient. Front page story, front page headlines, that's gone as well as a requirement. And lastly, and this is the crucial one, Minister, through the Chair, in all of the circumstances of the case, it was fair and reasonable to publish that statement. Is it fair and reasonable to publish a statement about a public figure that they are suspected by somebody else or alleged by somebody else, whether a Garda or whether an opposition TD or whoever, of corruption. Is it fair to put that into the public domain without some form of legal adjudication as to whether it's true or not, or without the matter going through the court process at the very least? And then, when you look at the additional protections in the existing Section 26, it says, for the purposes of this section, the court must, this isn't an option for the court, shall, in determining whether it was fair and reasonable to publish the statement concerned, take into account such matters as the court considers relevant, including any or all of the following. So, the extent to which the statement concerned refers to the performance by the person of his or her public functions. That's the first thing. Secondly, the seriousness of any allegations made in the statement. Thirdly, the context and content, including the language used of the statement. Fourth, the extent to which the statement drew a distinction between suspicion, allegation, and fact. That the story must be written, not Senator X corruption allegation. That the story must, and the statement must, draw a distinction between suspicions, allegations, and facts. Then, the extent to which there were exceptional circumstances that necessitated the publication of the statement on the date of publication. So if, for instance, an allegation of corruption or child abuse was made, why publish it now? Why not leave it to a jury? Why not? And this is a very good point. Why not, if somebody was accused of sexual assault, if they're brought before the courts, they're given anonymity for rape charges pending the outcome of the case. But a story under the minister's version, so-and-so suspected of rape, or allegation of rape against X or Y, a public person. That's you don't have to respect the anonymity of the individual because there's no court proceeding in existence. Then the business about the Press Council. The Press Council has laid down a code of conduct for journalists. It requires them to not to publish things which could seriously damage other people unless they go through an investigation of the matter themselves, and unless they afford the person about whom they're going to write the right to rebut what is said or to convince them that this is false. That's all they guaranteed under the existing law. And then we go, the extent to which the plaintiff's version of events was represented in the publication concerned and given the same or similar prominence as was given to the statement concerned. It's very, very easy to write a story. The guards say X, Y, Z. They are relying on a whole series of things, set that out in the story, and then say at the end of it, Senator so-and-so denied it. And under existing law, if someone's presumed to read the whole thing, and the fact that the person denies it is thrown in there at the end, but it's all over the front page of a newspaper. If the plaintiff's version of events was not so represented, the extent to which a reasonable attempt was made by the publisher to obtain and publish a response from that person, that's gone too. That's no longer part of this defence. What used to be fair and reasonable is now public interest only. And the attempts made and the means used by the defendant to verify the assertion and allegations concerning the plaintiff in the statement. So a duty was cast, and is cast by our law at the moment, on the person publishing the statement to go and investigate it themselves. Not just simply to say, oh, the guards say so-and-so, or this woman says that she was raped, or this man says he was raped. And as far as we're concerned, that's enough to go on. We believe him. We had an interview with him in the newspaper office. We believe him in good faith, and we believe that the public should know about this. This is the brave new world which the Minister is trying to persuade this House and this Parliament to bring about. Nothing else. And then, subsection 3, the failure or refusal of a plaintiff to respond to attempts by or on behalf of the defendant to elicit the plaintiff's version of events shall not A, constitute or imply consent to the publication of the statement, which is obvious. If you say, I'm not answering that, it doesn't mean I'm consenting to it being published. Or B, and this is crucial, entitle the court to draw any adverse influence. So if you say, I'm not answering that, I have no comment, or you literally simply don't respond to the telephone message left on your phone saying we intend publishing the following about you tomorrow, which happens, by the way. This is not me imagining situations. It happens weekly in our republic, that people get messages of that kind from investigative journalists. Weekly. If we're publishing this and we're giving you an opportunity to deny it. At the moment, they know that if you don't reply, they can't rely on that in the court for any purpose whatsoever. That's the law. So, I mean, there's a difference at the moment between saying, I have no comment to make on that, because they can actually publish senator accused of rape, details of the allegation that they believe to be true, and then add in that the senator in question said no comment, and stick that on their front page as their main lead story. Now, that's where we are going. And nobody should be under any illusion that that's where we are going. And why we are changing the law to permit this, I do not know. The present formulation, as I said to the Minister before, was considered clumsy. But there are guarantees in it which are hugely valuable to people about whom public interest defamation may or may not be published. Very, very serious safeguards which curtail media behaviour and impose good manners such as press council standards on them. All of that is to be swept away. All of that is to be swept away. You know, it won't be any good saying in court, why didn't you apply press council's standards and procedures and advice to the way in which you handle this story? It won't be any good to say that, because the fairness requirement is gone. It's gone out the window. And instead, we will have a new world, a brave new world, where somebody will be able to say, I have it on good authority from a member of An Garda Síochána, who perhaps should never have revealed this to me, but I've seen the file. I've seen the file. And there's reason to believe that Minister so-and-so or whoever is guilty of corruption. And do Gardaí leak files? Yes, they do, on occasion. I was amazed way back to the time when I was Attorney General. that a file was leaked to a particular newspaper and journalist, that there was somebody carrying out abortions in Ireland. And the next thing that happened was, and that file, by the way, was handed over in a city centre pub, as we later found out. And the next thing that happened was that women who were alleged to have had the abortions carried out of them, this is prior to the repeal of the Eighth Amendment, they had a journalist knocking on their door asking them to confirm that they'd had abortions by this doctor. Do Gardaí leak files? Yes, they do. Thank God the great majority of Gardaí don't leak files and comply with their duty of secrecy and confidentiality under the Official Secrets Act and under the Garda Code and under the Garda Síochána Act. But there are often cases where people who are frustrated that prosecutions aren't being authorised, that the DPP said no, that the DPP said the evidence isn't sufficient. Oh, we'll just throw it at a journalist and see if the journalist would make something of it. I'm damned if that person is going to get away with this misbehaviour. That's the kind of thing that happens. And it isn't just a matter of police activity. It's right across the board. It's people who are suspected of professional misconduct. Anybody in that situation is vulnerable to a file landing on the desk of a journalist alleging gross misbehaviour or gross criminal misconduct. And of course, the Minister's Amendment will facilitate a newspaper to publish that. Of course it will. Because it's in the public interest that there is serious suspicion about a particular person in public life. So it's in the public interest that they should know that. And as I say, the publisher has looked at the file and feels convinced by what he has seen, without the other parties' denials being there, that it's probably true. And of course, if it is true, as the publisher believes, well then the public should know about it. So publication of the public interest is satisfied. Good faith is satisfied because the person believes it to be true and believes it's wrong that this person should remain a minister or a TD or a senator or whatever else, if all of this information, which they have been given in confidence, is true. And Senator Craughwell made a hugely important point. This very day in one newspaper, a politician, a senior politician, we're told, is stated to have fronted up a charitable event where the money was misappropriated and where it was only devoted to the charitable object after inquiries were made. That's a very serious allegation to make about somebody, and I'm sure in the corridors of this House there are people saying, I wonder who that is. That's a perfectly natural inquiry to make. But what would stop somebody from publishing that politician's name, his or her name, this morning if the Minister's amendment becomes law? It's clearly in the interest, the public interest, that where a politician fronts up a charitable event and raises substantial money, and the money isn't applied for the purpose for which it's raised, that should be stated and publicly known. And it's clearly in the public interest that if that politician is so senior as to either have authority or have had authority, that those were the person's standards, that should be known as well. And if I've no doubt that the journalist who published that story today believes that every fact that he or she put in their story, which we're reading about, is true. So all the three ingredients in the minister's formulation of publication on a matter of public interest are satisfied. It doesn't matter whether it's fair or reasonable to publish it. The concept of fairness is taken out of the equation. It's just belief that the public interest requires it and good faith on the part of the person publishing it. In other words, an absence of bad faith. It would be totally different, of course, under the minister's formulation if the person knew it was false. But where the person believes it is true, good faith in its publication is satisfied if the matter is of such public import that the public should be told about it. Now, we are given a choice in this House, a choice which was not adequately debated in the House below, as to whether this should or should not be the new law in Ireland. That it should be possible to publish allegations which are of sufficient gravity to cross the public interest threshold in relation to publication, that are believed by a journalist or a newspaper to be true, and that that the defendant, the newspaper, reasonably believed that publishing the statement was in the public interest. Now, let's look at a fairly simple situation. One public figure alleges that another public figure has behaved corruptly. Let's take an example. In a coalition government, one minister accuses another minister of behaving corruptly in relation to the second minister's functions as a minister. And he goes to a journalist and says, I'm fairly satisfied that Minister X received money or made that decision because his son or daughter stood to gain from it. And here's why I believe that. And the First Minister is therefore under suspicion, and it could be credible suspicion, of corruption. All of the ingredients in subsection 1 of the Minister's new section 26, as proposed, are satisfied. There's no obligation to bounce it off the victim of that statement if it is a defamatory statement and is untrue. There's no obligation. You can say with abandonment, I put this to Minister B and he failed to respond for the last 3 days, which carries with it, in many people's eyes, a suggestion that there must be smoke or there must be fire because there's this smoke there. So I'm publishing his name and the name of his accuser, though I might actually give the name of the accuser some confidentiality because he was my source, and that's fair too. No breach of that at all. Is this the standard that we want to give to our journalists in future? And I go back to the 2006 or 7 bill, whatever it was, and I just want to say to the present minister through the chair, it was extremely carefully calibrated. It looked around the corners. It asked itself, what would the outcome of changing the law at that time to accommodate what was roughly what was the Reynolds defence in Britain would be in Irish law. And the balance that was struck was the balance that I've outlined to this House. And now we say, that was a wrong balance. It's too clumsy, too difficult, too constraining on free expression on the part of the media. Why force them to investigate the matter themselves? Why immunise a minister who says, I'm not responding to that on advice from his lawyers, who doesn't even return the pressman's call? Why give the media the right to say, well, Minister so-and-so was contacted and given 3 days to give us a response, and we haven't heard a word? Why do that? Is that the standard we actually want to have? And as Senator Crockwell has said, we have this very day an example of the newspaper which published a story about a senior politician which looks extremely unfavourable to that politician and has all the characteristics of a major defamation if any of it is untrue. But the newspaper then says to the public, for legal reasons, we are not naming that politician. Well, what are the legal reasons? The legal reasons are that the existing Section 26 doesn't accommodate them in naming the politician. That's where the protection lies. And today, if we pass this particular section, we are saying that those safeguards no longer exist. Now, at the time, I want to assure the Minister that all of this was discussed and debated in great detail. And that, for instance, the provision that failure to deny a story could never be relied upon was put into our law for very good reason. Because let's see him deny it is the oldest journalistic trick in the book. Because you can then say, Minister denies corruption, rape, or whatever it is. Shove it on the front of a newspaper. Or even Minister says no comment on the record when confronted with allegations of a very serious kind. We put that into law because it was necessary to put it into law. And it was a necessary protection, particularly for people in the public eye, that they would not be ambushed by telephone messages saying, we intend publishing the following about you. We want to hear from you by Saturday. Our Sunday edition will be carrying this story. And I can't understand how anybody would think that the terms of the existing Section 26 are unfair or unreasonable. Who is demanding that that politician written about in today's Irish Independent should be identifiable today? Who is demanding that? Is it the media? Is it the public? Is it curiosity? If that's true, we better know who it is immediately. Because the guards are investigating it. Believe it or not, the guards are investigating it. Not that the guards have found it's true, but the guards are investigating that a senior politician fronted up for a charitable event and the money didn't end up going to its charitable purpose. Why not name him? What protection is the minister offering him? Absolutely zero. And why was this amendment to Section 11 not much more widely discussed before it was made, and the terms of it and its implications more widely understood? Now, I've put it in terms which are designed to appeal, perhaps, to members of this House, because they can see very clearly that they could be in the firing line, and so could members of the Dáil, and so could members of the Cabinet. I put it in those terms without apology. But it was clear from Section 2, subparagraph A, which says that one of the matters the court had to take into account was the extent to which the statement concerned referred to the performance of the person of his or her public functions. But it doesn't just apply to politicians. It applies to senior clergymen. It applies to child protection officers. It applies even, dare I say it, to members of An Garda Síochána themselves. It applies to teachers, professors, university heads. It applies to people down the authority pecking order in the public service, passport officers alleged to have taken a bribe. It applies right across the board, this protection. And what the minister is proposing to do is to radically change this section. Now, I myself, because I was involved in the political compromise and authorhood of the existing Section 26, I don't claim it's perfect, and I can see that it to some extent requires some reform. And I'm happy to debate with anybody changing any of the existing protections or qualifying them in any way. But when I'm confronted with a proposal to sweep away virtually all of the defences that the ordinary citizen or person in public life at whatever level has in the face of a public interest test of the kind proposed by the minister, I have to say this goes far too far. It goes far too far. It's not balanced. It's not balanced at all. I will go along with, if the minister says it's too restrictive, I'll go along with him making the case to this House it's too restrictive for the following reason. This kind of case is, this kind of publication is being wrongly inhibited, or juries are confused by some of the language in the existing Section 26, or it's too long, or it's too clumsy, or the reference to the Press Council is otiose and redundant. Any argument I will listen to, but an argument that none of this should remain our law and that should be entirely swept aside, I can't accept. And I don't think it was adequately debated in Dáil Éireann, or its implications were. And I think if this afternoon the members of Dáil Éireann looked at today's Irish Independent and said, when Minister O'Callaghan manages to get this through the Seanad, that person would have been named this morning. They might think, were we wise to permit such a change in our defamation law? So I think I've made my points. I'm not saying that Section 26 is perfect. I'm quite happy to acknowledge that somebody could, in good faith, believe it required amendment. But the radical chopping down of most of the tree to leave it as simply a matter of public interest, publication in good faith, and the requirement that its publication should be was believed to be in the public interest is a ridiculously low standard to apply. If every single other constraint which is in the current law is taken away at the same time. I mean, even if the word fair was taken away, because I can well imagine juries taking a bit of a run at the present law and saying, well, yeah, that's all very well, but it wasn't really fair. And that's the end of it. Even if the word fair was recast, I can see, to make it clearer to juries what was involved. I would happily debate that and see if there was a formulation which was better. But I can't accept the proposition that the amendment now proposed by the Minister would have anything except really harmful effects on public affairs in Ireland. And I make one last point. In the context of the recent presidential election and the nominations process, very vicious things were written, not just the one that Senator Crockwell described, online. Very, very vicious things were said. And it struck me on occasion, who would put their head in the firing line to receive such vicious, often defamatory, obloquy, anonymously online about them? Who would go into public life if journalists are given a free potshot at them as long as they can invoke the three grounds of the Minister's proposed Section 26? Wouldn't it be wiser to do something to halt and reconsider whether the whole process of liberalisation, about which I wrote in today's Irish Times, the whole process of liberalisation can go too far. It can get to the point where public democratic values are under threat, where participation in public life is unsustainable psychologically and from a family point of view to people who are tempted to play their part as citizens in the democratic life of the state. It can have that effect. And, you know, when you're on the wrong side of public opinion on occasion, you get to understand how intense the blizzard can be. And when in addition to that, people can write whatever they like, provided that it's a matter of public interest, that the defendant reasonably believed that publication was in the public interest, and that the defendant believed or published it in good faith, that those are the only defences open to people in public life in future. And, those are the only criteria for assaulting people in public life in future and destroying their reputations. You know, we have to ask, what is it that the media want to publish now that they are being inhibited from publishing? And today's Irish Independent story is a very, very good guide to that. If the Minister's amendment were published, that woman or man's name would have been front page story in the Irish Independent, and tomorrow in all the newspapers and on broadcast media. And let's see him deny it, let's see him defend himself, let's see him pick up the pieces of what would be left of his reputation if that story was given national prominence, identifying him. It's in the public interest, American style. Let's see him deny it. Let's see him deny it. I really do ask the Minister to drop this amendment. Drop it. Or alternatively, that we, and let Dáil Éireann have a second look at what he's proposing. And I'm not impressed by the fact that in Dáil Éireann there was little or no opposition to it. Because there's a certain cowardice in that chamber and deference to the media, and fear that if the media says X or Y, my party or my own personal reputation or whatever it is will suffer. And if the media demand this, it should be done. And if the Minister is willing to go along with it, so be it. But I do think that both houses should, and by the way, the Justice Committee in particular, should revisit this before it becomes law. Because once it is law, the dam is burst. Trying to pull it back is impossible. Trying to pull this back will be virtually impossible because the media will say, this is great. We have free-fire conditions now against people that we disapprove of in public life. Let's see them sue us in future. And you know, I will say this too, that the Sinn Féin party are fond of suing people. And they didn't oppose this in Dáil Éireann. Big surprise. Big surprise. So I'll leave it at that.
Shandur Conway.
When you reach my age, it's not all that easy to be shocked by things. But I have to say, the bar is being crossed here today because the section that's been discussed or under discussion today, I find as a Democrat and as somebody who treasures free speech and fairness in public life, I'm really truly shocked by the proposals here in this measure that's under discussion. Most of us here would remember an August day in 2014. South Yorkshire Police making a raid on a very prominent entertainer's house in Sunningdale in the UK, Sir Cliff Richard. And the raid on Cliff Richard and his reputation and his standing, from which he has never recovered, was accompanied by, I suppose you could nearly call it a squadron of helicopters filming the raid from the air. The squadron of helicopters was chartered by the BBC. The news hounds of the BBC who were there watching the ignominious disgracing of a national treasure, as they would call it, by a news media, the BBC News. Now, people very quickly began to ask the question, how in God's name were they so attuned to what was going on in the legal world that they were able to charter, prepare, do all of the infrastructural preparation with these aircraft to film the bringing down of Cliff Richard. And of course, it was manifestly clear that they could only do this with the involvement of the South Yorkshire Constabulary, who were the people who were manipulating the investigation of Cliff Richard on child abuse allegations, which of course he was never even charged with, let alone been tried with. But effectively, the man was shattered, and his reputation was shot to shreds, and he never graced a stage again, as far as I know. And the BBC had to fess up and it was painfully obvious what had happened, in the fact that the police were attuned, shall we say, to the newsroom in the BBC. And the BBC were given the privilege of passing over £250,000 of the taxpayers, the licence fee payers' money, to absolve themselves of a completely scurrilous and unfounded allegation. So I'm just using that as an example to say, Senator McDowell mentioned, do Garda leak files? Are there corrupt people in police forces around the world? Well, if you're as old as I am and you're reading books and periodicals and newspapers, you know, of course, that, as they say, in every barrel of apples there is a rotten one or two. And it only takes one or two of those then to shaft somebody like me or any member of this House or the lower house, or back in the day when it was becoming much more commonplace to talk about child abuse and child sexual exploitation. I remember a stage like when I started teaching back in the 70s, such things were never on the agenda, never on the horizon. But within 15 years of teaching, it was beginning to creep in, and there were more cases and allegations. And we used to say, when we'd have ITO meetings and we'd go for a few pints afterwards, and the common wisdom then was, we're very vulnerable now because you don't have to be guilty anymore. All it has to be is that somebody makes an allegation, and you might as well be guilty, because in a local town or a village or a county or wherever, if somebody says such and such a teacher or a headmaster is fondling children with after-school sporting activities, well, it may never come to court, and it may never come to serious investigation by the Garda. But that man, or it's nearly always a man, his reputation in that locality has gone to the dickens. And lots of my friends say to me, "What do you do up there in Dublin all day in the Shannon, for God's sake? What do you do up there?" And I find this quite amazing, because I'm only a half year in the job, and I find myself standing here speaking to about 10% occupied chamber, practically nobody from the government here, practically nobody from the so-called opposition, except a few diehards. And at the same time, we're trying to nail down one of the basic tenets of the democracy that we try to live by, and that's the tenet of fairness. And I'm just wondering, are we going to toss it away, on a non-considered Section 26 in the lower house, and a poorly considered, were it not for the intervention of Senator McDowell here on my left, who gave a very, very trenchant exposition of the dangers, of the chasm that we're blindly walking across, down into the depths where anything will be possible with the media. And I was just making some notes there, and just put on the old spectacles here to have a look. Oh, yeah. I have down here just a note for myself, a speaking note, Nixon. Now, we will all remember that paragon of the defense of legal rectitude, the man who was the President of the United States, Richard Nixon, whose favourite catchphrase when he was dealing with his henchmen and he had an opponent was, he would say to them, "Give him something to deny." That's all it took. Give him something to deny. Is that fair? Is it reaching the bar of fairness? Look at the other things we have here. There's a questioning about the ability of people and the rectitude of the way they do their public functions. Do the allegations have seriousness? What about the language used? Suspicions. Do we have suspicions, allegations, or fact? Was there the urgency in the report that would be at one with the strictures of the Press Council and its equivalent standards? And then I have a note here for myself about Mandy Rice Davis, and I'm sure an awful lot of people here won't remember, in actuality, Mandy Rice Davis. But she was back in the Profumo affair, back in the Harold Macmillan government in the UK. And she and Christine Keeler were up to hijinks with John Profumo, who was a Minister for Defence Procurement in Macmillan's government. And this is going back a good way now.
We have a definition of jinx, please.
But when the famous thing, that the famous phrase that Mandy Rice Davis was connected with was when people made a rebuttal of an allegation, she said, "Well, he would say that, wouldn't he?" And this is the sort of thing that attaches to people who are ringing up public figures, and they're asking them, we have credible evidence, well-appointed sources, sources close to the Garda. These sort of phrases that mean nothing really, they're just conjectured by journalists. And they're put out there in the public domain after there's a consideration of the so-called allegations. And oftentimes the people who are at the butt of these, who are having their world kicked out from underneath them, are phoned up usually, by the journalists and say, we have these credible allegations, well-placed sources, sources close to the Garda. People have seen the files. What are you going to say? And of course, usually in panic, they phone up their solicitor and say, what in the name of God am I going to say? And the solicitor says, say nothing. You don't have to say anything. And usually that puts a halt to the gallop at that stage for a while. But if we are precipitate enough to throw away the protections that are in the legislation currently, if we throw those away today, we are doing a big disservice to democracy, to fairness. Now, I'm speaking as a layman, I'm speaking as a former teacher, I'm speaking as somebody who values the whole business of democracy and fairness. And I have to commend the minister. Of all the ministers that I've seen in the last 6 months, he's the person who is most assiduous in his attendance at the Senate, at the Shannon. He's fantastic. And I'm high in his admiration. I'm high in admiration of him, and I think he is an extraordinary minister, an extraordinary public representative. But on this occasion, I fundamentally think, guys, gals, the man may be great, but on this occasion, he's damned wrong. And I hope that we have. I'm not encouraged by the tendency on the divisions of this bill that they are going through and not, but you have an odious responsibility on the government side and with the minister to step back from this and not to press it ahead, because we are doing ourselves a desperate disfavour.
Shandor Crockwell.
Minister, your ears are probably being burnt off you at this stage. We have a problem. We have a serious problem. And this amendment will actually make that problem worse. When we talk about the article in the Irish Independent today, it quotes sources from An Garda Síochána. Why is there not a criminal investigation today into the source that leaked that story to the Irish Independent? Journalists, without ever naming a politician, can destroy a career in the way they write stories. Claims to have seen files, claims to have seen evidence can be printed without any evidence that it's true. Members of An Garda Síochána who served this state with honour and have served this state with honour for over 100 years advertise frequently asking people to come forward to confidential lines in order to provide evidence where a crime has been committed. Who in their right mind would come forward with evidence knowing that there's a fear that their name would be released, knowing that there's a fear that the evidence they would provide would be released? That's one problem we have. If this amendment goes through, and people will often say to those who feel they have been defamed, well, you can go to the courts. It's not that easy to go to the courts, and there is risk in every court case you will ever take. But as my colleague Michael McDougall has said, there are now only three things you have to satisfy. One, that what you're publishing was in the public interest. Two, that you believed it was in the public interest. And finally, that you did it in good faith. How do I prove, or how do you prove, or how does a minister or a senator or a county councillor or a priest or a teacher prove that a journalist did not act in good faith? How do they prove that? I had experience some years ago of a teacher who had been alleged to have carried out a sexual assault on a student. And after a period of investigation, the student actually came forward and said, well, actually nothing happened, I just didn't like him. And when he sought a timetable to go back into his classroom, they said, well, you know, we're not really happy about that because there's no smoke without fire. The man had been exonerated, but there was no smoke without fire. Now, we have seen a plethora of publications in this country based on innuendo. Imagine what that will change to if this legislation passes. You made the comment yourself there, Minister, about the two people in a pub talking, right? Two people in a pub talking. It was in an earlier part of the debate, Senator McDougall was referring to the Boeing aircraft, two people talking, they're dangerous aircraft. Boeing are not going to go after them. A journalist sitting there now may very well say, Joe Bloggs said, and Joe Bloggs happens to be a very wealthy man, so Boeing might just go after him for the hell of it, why not? The number of times that I have sat in company, and I'm sure you have, where somebody has stated a fact that is totally untrue and that everybody knows it's untrue, sitting around the table, and the person making the statement is making it with such conviction that they know it's an absolute fact. But of course it's not a fact. We see it on social media every day of the week. I am delighted I am Twitter free for 3 weeks now. Right? And I will never go back to it because it is a horrible cesspit full of people who will say things with impunity and destroy people's lives, cause people to sit up at night worrying over things that are said, right? It is a horrible, horrible place. But I would say to you, Minister, please, firstly, do not proceed with this amendment. Come back with another amendment at the report stage and let's all work together to get this through and to get to where you want to go with it. I would plead with you to do that because as Senator McDougall has said, if this goes through, it'll take God knows what to reverse it. But the other thing I would say to you, Minister, and you are Minister for Justice, and we now have a new Garda Commissioner who I met recently, a fine policeman, with great service to the state. We have to plug the holes and stop journalists attributing to Garda sources stories that they publish. I believe our Gardaí are above that. And if there is one or two bad apples, as my colleague Senator Conway said, if there's one or two bad apples in there, let's weed them out to hell out of the place and stop the constant attack on people in public life. And if we go ahead with this, I'm afraid you're going to see every election, you're going to see innuendo now with names attached to it. It'll be no longer sources close to, and it'll be no longer Minister such and such or TD such and such. It will be source told me that John Murphy was A, B, C and D, and that's John Murphy then having to explain. And we all know in this House and in the lower house, when you're explaining, you're losing. And that's something we've got to be extremely careful about. So I would ask you to do that. I'm not going to delay you any longer myself. I think you've had a good airing.
Shandor Mullen.
Gurmila Margaret, Lascairlig. Minister, I'm afraid I'm going to be one more voice contributing to the rumour of your fallibility on this one. I think Senator McDougall offered an answer to a question that I had in my mind when I read this section, this dramatic proposed change to the law, which was, how did this section survive? How did it escape the scrutiny of the Dáil? I felt the same about this section that I did about the ill-fated so-called hate speech legislation last year, in that here it seems to me is legislation that fails to understand and respect the necessary balance that must be there in order to protect freedom of speech, the expression of ideas, the expression of opinion, and on the other hand, and at the same time, to protect people's right to their reputation. Another thing that strikes me is that what's in this section is so out of kilter with what the Ceann Comhairle had to say recently at the beginning of the Dáil term, when she basically called out the abuse of politicians in particular, and asked for all sides to work together to combat it. Asked for all sides to work together to combat it. And when I heard her comments at the time, I wondered, well, what does she mean? Is this going to be something that will be, or were this to be acted on or interpreted in a particular way?
Sir Mullen, I'm going to have to ask you to report progress.
I report progress.
As it's now 4 p.m, the debate is adjourned by order of the House today, and Senator Mullen